are not giving any cooperation to the Commission, who are not assisting the Commission with its investigation. But when it comes to persons who may be giving evidence in the Commission and assisting the Commission to unearth more wrongdoing, they may have to wait a bit.
Yes, I understand.
Yeah.
But where they have enough evidence, Chair,
Yeah.
and the work of the Commission would not add much to the evidence they have, I don't understand why they should stop executing their mandate simply because they're waiting for the Commission.
No, I think there is engagement going on, and I'm sure it will clarify things.
Yes.
Yeah.
And the last recommendation, Chair, is that Eskom must make applications in terms of Section 162 of the Companies Act to have any former board member who acted within the immediately preceding 24 months and implicated in fraud, corruption, and or other unlawful behavior declared a delinquent director. You recall that those are the court powers which, once are exercised and you are declared a delinquent director, you will no longer be entitled to occupy an office of a director in this country. And
I haven't looked at Section 162, but I'm wondering whether the limitation to 24 months has anything to do with something that might be in that section.
No. The section, as far as I read it, gives any of the listed persons, a shareholder, a creditor, and other persons mentioned, to approach the court to have a director declared delinquent on grounds specified in that section. As far as I know, it does not have any limitation.
Yes, because, I mean, there may well have been people who acted in a certain manner around 5 years ago. Why should they be spared?
Yes.
Yeah.
I suspect the committee made this recommendation on the basis of the information placed before it, but we accept that there's no reason to confine the Commission's power insofar as it's entitled to make recommendation to Eskom to that time period.
Yeah.
And so, Chair, those are the gaps which the committee identified in relation to the remedial measures it recommends.
Yeah.
It remains for us, Chair, to draw your attention to the last aspect of the committee's recommendation that affects the closing of the gap analysis. It is at page 981.
981.
Yes, Chair. Okay. And it talks to the earlier issue we raised concerning your power under Section 310, as if the committee would have presciently been aware that we're going to ask you to consider the exercise of those powers.
Yes.
At page 981, paragraph 4.4.1, the committee says the following. The committee recommends to the National Assembly that the witnesses mentioned below must be requested to present themselves to the Zondo Commission of Inquiry in order for them to shed more light on the allegations of corruption and state capture at Eskom during their tenure. The list are mentioned there, and I don't think that I'd like to mention them here, Chair.
Yeah.
But those are the list of persons who we respectfully suggest.
Well, some of them are quite well known to lots of people, but that doesn't necessarily mean we mention them, but yeah.
Yes. And Chair, it's important that these persons must present themselves to the Commission to put up their version, because their version was not fully explored before the Commission. And we can...
Before the Portfolio Committee.
Before the Portfolio Committee. And we can also indicate, Chair, that those who have had the privilege of appearing before the Portfolio Committee have subsequently been accused of misleading the Commission.
Oh.
The Portfolio Commission, so the Portfolio
I assume
Committee.
some of them, not all of them.
No, not all of them.
Yeah, okay, yes.
Again, I won't mention name for now,
Yeah.
but some of them have been accused, and Eskom has charged some of them
Yeah.
for misleading the Portfolio Committee in the course of its
I seem to
investigation.
remember that.
Yes.
There's at least one name, yeah,
Yes.
or maybe two.
I can recall two offhand.
Yeah. Yeah, and I think I see the names that I'm
Yeah.
remembering here. Yeah.
Some of the names are there. I
Yeah.
think the two that you're thinking about, I
Yeah.
can see some of them here.
Yeah. Yeah.
So it is vital that those persons, Chair, regardless of Rule 310 powers, that they have to present themselves before you. And that, Chair, is the report of the Portfolio Committee. It takes me to page 23 of the slides. Chair, I now get to the first chapter, the first of the Funduzi report.
Oh, when you say it took you to page 23, you mean you have covered up to page 23 of the slides?
Indeed.
Yeah, okay. Yes. And where do I find the Funduzi report?
It's volume 4.
Yes.
And Chair, you would remember that the Funduzi report of relevance to the work of the Commission has been presented in chapters 2 and 3 of that report. The first one before you begins at volume 4, page 986.
Is that under file 5?
Under file 5, indeed.
Yes.
And you'll see that it's chapter 2, dealing with their investigation on behalf of National Treasury relating to McKinsey, Trillion, and regiments. The first part of that report relates to Transnet. And for the present purposes, we'll skip it. We will ask you to go to page 1225, which is where it begins with its investigation into Eskom concerning the involvement of McKinsey.
1225 I've got. For convenience, shouldn't we have a divider there that can help? Or will that cause confusion?
No, I think we'll ask them to put a file divider, not as big as the one that divides the volumes.
Just something to indicate this is where the portion relating to Eskom starts.
Yes.
Yeah. And that the other portion is something else.
Indeed. And, Chair, Funduzi investigated the so-called the Top Engineers Program relating to the appointment of McKinsey at Eskom. It is a program which began in 2015, April, during the proposal stages. You will see the date is given in paragraph 7.7.1. And then they explain the nature of the program And they detail how it evolved ultimately into some kind of a service level agreement. And Chair, I'm not going to ask you at this stage to look into the process because it's a matter that we will deal with when we present evidence of oral witnesses. Having outlined the nature of the program, the issue that Funduzi engaged with related to payment of several invoices to both McKinsey and its BEE partner, Trillion. You will see that they identify the issue of the invoices on page 1244. And you will see that in relation to McKinsey, the amount of it is set out in paragraph 7.1.106, divided into 2 tranches. The total amount is slightly in excess of R1 billion in regard to 2 invoices. You are given invoice numbers. And then if you turn over to page 1245, there is an explanation of invoices from TMC, which is Trillion Management Consulting. They are given in detail, Chair, at page 7.1.110.
Paragraph.
Paragraph, yes.
Yeah.
The total amount is shy of R500 million in rand figures. And after its investigation, Funduzi came to the conclusion that that contract was unlawful because it was a risk-based contract which did not comply with Treasury guidelines and instructions. It also came to the conclusion that it was unlawful because Eskom failed to follow its procurement procedures. I have indicated to you that in the end, Eskom took court action to set aside that contract. It is before the courts. I'm not going to say anything more about it. But what is quite crucial beyond the validity of the contract are the recommendations that Funduzi made in relation to the conduct of the parties involved. You will find it at page 1281.
Yes.
There, Funduzi says, based on the conclusions discussed above, we recommend the following. DPCI, which I take it to mean the Hawks, should investigate if Singh, who we assume is Mr. Anuj Singh, the Chief Financial Officer of Eskom at the time, Mr. Sagar, who we assume is Mr. Vic Sagar, an employee of McKinsey at the time, McKinsey itself, regiments, and any other role player did not receive gratification in terms of the Prevention and Combating of Corrupt Activities Act. You will recall that the Corruption Act in that regard, Chair, has a wide definition of what gratification means. It is no longer like in the past, limited to the question of receiving financial benefits of some sort. It extends to even receiving some kind of official favor in the execution of duties. And Funduzi says you must investigate that issue in relation to those specific individuals. The next recommendation reads as follows. DPCI should investigate if Mr. Singh, Sagar, McKinsey, Regiment, and any other role player did not contravene Section 34 of the Prevention and Combating of Corrupt Activities Act. Again, here, Chair, recall this is a section which is different to direct acts of corruption and reception of gratification. It's a section that imposes an obligation on any person in authority to report his or her knowledge of corrupt activities that take place in his presence or otherwise. And what is quite interesting about this recommendation is that the business rescue practitioners, when they pick up suspicions around the payment relating to the Optimum coal mine acquisition, they fulfill their duty to report that suspicion in terms of Section 34(1) of the Corruption Act. And we would submit that this recommendation by Funduzi is even more applicable here, because these are the individuals who would have been aware of suspicions of corrupt activities in relation to their involvement or knowledge of the transactions involved. So that's the issue that we will explore when we come to the McQuincy Trillion issue.
Okay.
And Chair, that's the first part of the Funduzi report. You will see that we deal with that report in the slides from page 24. And at page 26 of the slides, we summarize the findings for you.
Yes.
There are many. They end up at page 28. And at page 29, we identify the gaps. And those are the gaps that I have already dealt with, with reference to the body of the report. But the summary of it is at page 29. And we respectfully submit that the Commission will be well within its power and, in fact, its obligations to fill up those gaps. That takes me to Chapter 3 of the Funduzi report, which you will find in the next volume, that is volume 5.
Yes.
Chair, you will see that this report begins at page 6.
File 6 or page 6?
Sorry, did I say page 6?
Yeah.
File 6.
Yeah.
And it is page 1282. And you'll see that the heading is Chapter 3. It relates to their investigation specifically of Eskom.
Yes.
There are several aspects of the Eskom investigation, and I'm just going to highlight them for you for the purposes of your notes. You will see at page 1326, they deal with the Blackfountain contract.
Yes.
I'm not going to say anything more about it. All I want you to note is that at page 1360, they deal with the question of coal testing and the signing of CSA in regard to coal from that area. And at page 1372, they deal with the performance of Tegeta relating to that CSA around coal deliveries. And the same issue of coal quality is dealt with and investigated and of course reported on from page 1381 from paragraph 6.16.6. And then, Chair, there is a question of payment. 6.16.6.
Yes.
And they give you chapter and verse of the persons involved. And Chair, it involves a lot of detail that you will be told about when Blackfountain evidence is presented.
Yes.
And then at page 1415, they give you a table of the amounts that were paid as against invoices for coal delivered.
Yeah,
and it's 1.1 billion. And then they begin to identify issues raised by National Treasury regarding its investigation of the coal quality from Tegeta and the responses of Tegeta from page 6.29, from paragraph 6.29.22. And they deal with all sorts of things, including SAB testing and you name it. And ultimately, Chair, they make some conclusions, and I'm not going to waste your time other than to ask you to note that their recommendations based on their findings are set out in page 1420. From paragraph 6.29.40.5. Again, they recommend in regard to those issues that the Hawks should investigate which role players did receive gratification and which role players contravened Section 34 of the Corruption Act. They also recommend the taking of disciplinary steps. And that is the gap which Funduzi, in relation to the Blackfountain contract, asked the Commission to consider. And it's a gap that we would fill when we present the Tegeta leg of the evidence. Chair, they go to the next topic relating to Tegeta, and it's at page 1421. It is the question of the prepayment to Tegeta for the supply of coal. In paragraph 7.1.1, they give you the amount of 6.59 million by way of prepayment. On any version, Chair, there will not be a dispute as far as we are aware between the protagonists who support the question of prepayment and any implicated person who may contest that prepayment, that as a matter of fact, Eskom did make prepayment. There was an attempt to suggest that that was not a prepayment when the Portfolio Committee heard evidence from some of the executive of Eskom. We would like to hear what is the justification for the suggestion that that was not a prepayment. But we feel confident at this stage that the body of evidence indicate without doubt that that was a prepayment. And you will see when we also present the evidence of the former director of the Department of Mineral Resources, that even at that stage where DMR was asked to become involved.
The former Director General.
Former Director General,
Yes.
Indeed. I think we refer to him as Dr. Ramoncha. Even at that early stage, the question of prepayment was foreshadowed, and was foreshadowed in a different narrative of trying to assist whoever would be the new owner of the Optimum coal mine to fulfill their duties. So we would submit that whatever a contrary version may have been put before Parliament, it would not be sustainable by the reference to the body of the evidence presented to the Portfolio Committee. And of course, in the light of the investigation by Funduzi, as we are now discussing. And Chair, from paragraph 7.2 onwards, it gives you a wholesale background in relation to that prepayment. I'm not going to ask you to go into it. We will take it further via the evidence. And then in paragraph 7.4, they discuss the question of Optimum Coal Holdings as a coal supplier under the CSA. And it's a long, long, long discussion. But where it ends, Chair, is at page 1431, paragraph 7.8.4, the selling of Optimum coal mine. And you will see that they deal in subparagraph 1 about the penalties that Eskom imposed on Glencoe of 2.1 billion. There's the first leg of the penalties. And Chair, what is interesting is they jump quite quickly from the penalties that Eskom imposed on Optimum coal mine when it was still under the regime of Glencoe control, to a totally set of penalties after the ownership of Optimum coal mine was transferred to Geta. And you will see that they record on page 1432. Paragraph
Yes.
7.8.4.4.
Yeah.
The exact value of the penalties remained a bone of contention until resolved by an arbitrator at a reduced total of 577 million rand. The said reduction occurred after the sale of Optimum Coal Holdings subsidiaries to Tegeta in a sale agreement concluded on 14 April 2016 after the payment of 2.15 billion by Tegeta. So there, the scenarios which we would ask you to consider when we deal with that issue is the quantum of the penalty before the sale, 2.1 billion, and the quantum after the sale, when the mine is now owned by a different entity, of almost something in the order of 600 million rand. That is a substantial
The difference
reduction.
is just more than substantial.
Indeed,
Yeah.
indeed. And we would like to hear the Eskom executive who have been involved in this regard. And I do recall that some of the emails that we will refer you to, hopefully through the evidence of the Eskom cyber experts, that there were some of them which deals with exchange of confidential information on that score. And we would like to deal with that part of the evidence, Chair. And then, Chair, I'm not going to waste time by pointing out to you that there was a competition by other rivals of Tegeta for the acquisition of Optimum coal mine. One of them is mentioned in paragraph 7.8.6, but who ultimately fell out simply because of the way the pressure was put on the business rescue practitioners. And Chair, on 1434, paragraph 7.8.7 deals with the transfer of shares. Chair, I'm going to move quite quickly in the interest of time to take you to a different topic which is related to the Optimum coal sale of shares, and that is the 1.6 advance billion, which is mentioned at page 1438.
Yes.
And then on page 1439, they deal with the APSA guarantee.
Yes.
And Chair, one of the emails that we discovered, which we will present before you, of course, through the lawyers of Eskom, was an email that copies a number of people relating to this guarantee, requiring external services providers who had nothing to do with that guarantee to advise Eskom on it. And a number of questions arise from that email. I can indicate to you that it was sent to representatives of Trillion,
Yeah.
including Mr. Wood or Dr. Wood, to advise Mr. Singh on it.
Yeah.
And we wonder what was their interest in it, because they were not contracted to advise Eskom on that guarantee. And that raises fundamental questions about their involvement in that part of the guarantee.
Yeah.
And Chair, you will see then that from page 1443, Funduzi begin to talk about electronic mail communications between, on the one hand, Eskom's executives and some of the directors relating to that transaction.
Yes.
And you will see that at page 1444, they talk about the shortfall of 600 million relating to the purchase price of Optimum coal mine. And there are at page...
I'm trying to see the shortfall of 600. I see 600 million. I see 500 million. Is that what you are referring to on page 1444?
Yes, Chair. If you look at the heading in paragraph 7.8.24, the heading is Tegeta short of 600 million.
Oh, yes. I was looking 2 paragraphs above that.
Okay.
Yes, okay.
And again, that's a well-known topic, which indicates that by the 11th of April 2016, Tegeta was short of 600 million rand to fund the 2.1 billion acquisition of shares in Optimum coal mine. And remember, at that time, the clock was ticking for the fulfillment of the CPs. And as I recall, the critical date was the 13th of April for the fulfillment of the conditions precedent, one of which was demonstrate the money. Because if it did not by that day, then the transaction falls away.
Yes.
And so between the 11th and the 13th, 600 million had to be found in order to provide for that shortfall. You will hear a lot of evidence here about how officials of Eskom, one of whom it will be I think it's Mr. Nega, who will come to you and explain how within a period of a morning, Eskom's processes were accelerated to bring about payment of 600 million by way of a prepayment. And again, there are email exchanges of a private and confidential nature, which were exchanged between officials of Eskom and third parties who had no right to receive that information, but who had interest in this transaction chain. And that's another element of filling the gap, Chair. That, Chair, talks to the elements of the Tegeta acquisition of the Optimum coal mine. Perhaps I'm not doing justice, Chair, on that score if I do not draw your attention to page 1448.
Yes.
Which deals with the Board Tender Committee meeting of 11 April 2016, which was convened for the purposes of approving this prepayment. Funduzi makes some observations in that regard, Chair, that a special board meeting was convened, which by round robin late in the evening authorized this prepayment in circumstances where there was a scheduled board meeting already to take place on the 13th of April, 2 days later.
So it was brought forward, or it was just an additional meeting?
It was a special meeting called for this purpose, when there already exists a call for the meeting 2 days later.
Yeah.
So there must have been something urgent around authorization of this prepayment. And let me be clear, I'm not suggesting that there is no explanation. Of course, there may well be. But for now, Chair, we don't see any explanation why there ought to be an urgent meeting held in the evening via a round-robin resolution in order to authorize a payment of this scale and amount. And so, Chair, that would take me to the conclusion Funduzi has reached and the recommendations they make, and they appear on page 1465. And Chair, the recommendations are set out from page 1468. That the persons mentioned in that paragraph at the bottom of the page, and again, I won't mention their name for the purposes of our introductory submission, that they should be investigated for possible contravention of the Corruption Act. The names go over the page, Chair, and there are many. And the last issue, Chair, which relates to the closing of the gap analysis, as far as we pick up from that report, begins at page 1475. It deals with emails exchanged between Eskom's executive relating to request for payment of monies into certain accounts. Paragraph 8.7.5 begins the analysis, Chair. And I'm not going to mention the names, but you can see the names of the executives involved there.
Yes.
And in paragraph 8.7.6, you are given the private emails.
I think, and non-executives, or at least one non-executive.
Indeed, Chair.
Yeah.
And you will see the body of the email quoted in that paragraph. Hello, so-and-so, how are you? I need you to prepare and wire transfer for a payment. Let me know if you are available so I can send you transfer details. Thanks, sent from my iPhone. The rest is there. And then the next email, Chair, is dealt with in the next paragraph that follow of 9 November 2015. If you go over the page, you will see a further trail of emails which gives you details of the bank accounts, and Standard Bank is one of them. And you will hear evidence of Standard Bank. And then at paragraph 8.7.6, Funduzi says that we analyzed Mr. or Mrs. Dash emails and determined that on 9 December 2015 at 10:07, there was indeed an email sent from the email address concerned to so-and-so. We further established from those emails that Mr. so-and-so indeed sent an email inquiring whether it was so-and-so who sent the email. Again, Chair, the same email addresses are used in respect of further requests for the transfer of money. I won't mention the names and the details, but they're there. And then in paragraph 8.7.7.3, there is an interesting conclusion that Funduzi make. The above communication is just a snippet of the transactions that took place relating to the requests to make payments into certain bank accounts by either Dash or an individual who calls himself Dash to Dash. The fact that Dash participated in the said communication and appears to have executed the instructions without asking any questions reinforces the fact that he knew that the individual he was communicating with was Dash or a person purporting to be Dash. I have tried to extract the quotation as fairly as I can, Chair. But it's important because that's the conclusion which is before you. We would seek to reinforce it via production of the relevant hard copies of the emails before you. And Chair, look at the response when Funduzi...
You may already have done this, or you might not have done it. It would be helpful if when one goes, or when one reads and comes across certain important findings in any particular report, to one has something to refer one to where the material is that could be looked at to examine if the finding is justifiable.
Indeed, Chair.
Yeah.
Indeed.
Okay.
So what we'll do is we'll have an analysis of where the findings are with reference to the paginated papers.
Yes.
And where we say they are justified or not.
Yes.
And if not, we say why.
Yeah.
But it will be in the form of columns.
I think that will be helpful, yeah.
And Chair, Funduzi did not end up there in terms of making its own conclusion. It took a further investigatory step, which it deals with at page 8775.
You mean paragraph?
So paragraph 8.7.75.
5, yeah.
And it says, in his response to our questions relating to the requests for transfer discussed above, Dash, through his attorneys, responded as follows. The emails referred to in the draft report were not authentic due to various email domains being hacked. A criminal case was filed with the South African Police Service in the respect under case number, and the case number is given. No payments were effected in accordance with this bogus email instruction referred to in this report. And Chair, Funduzi did what any reasonable investigator would do, is to go to the relevant police stations to ask for details relating to that case number. They found nothing. Instead, the case number relating to the same person related to a totally different incident. And you'll see that they summarize their findings on further investigation they did on 1479. And I read from 87754. Captain Motsai further stated that the Sandton police station has no record of a criminal case opened by Dash in respect of alleged email domains or any other criminal activity. Captain Motsai stated that the only record appearing on the system registered by Dash was in respect of a car hijacking which took place in Durban during 2012, and the case was opened at Durban Central Police Station with case number Dash. And that's the gap which we would like to fill, because on the face of it, the legitimacy of the emails has not been questioned. The explanation does not detract from the legitimacy of those emails. Chair, again, there are further emails. I'm not going to bother you. You'll find them from page 1480. They go on and on up to page 1483. But again, revealing the same analysis which Funduzi undertook around emails from Eskom's officials, exchanged between themselves and or third parties, and the conclusions they make. One of the email address that I'd like you to note, because it's going to play a central role going forward, is the email address identified at page 1484, paragraph 9.2.1.4. You will see that it's an email address referenced as infoportal1@zoho, zoho.com. It features quite a lot in the various emails. The holder of that email address seems to move from one person to the other. But whatever is clear is that the holder of that email was not an employee of Eskom. In fact, it was the employees of Eskom who sent confidential confidential information via emails to this address. So as and when witnesses come to you, we would like to explore precisely who was the holder of that email address. We have our own suspicions, but they're irrelevant. What is relevant is the evidence. So, Chair, ultimately, Funduzi, based on all of those investigations, make recommendations and you will find the recommendation at page 1491. And the recommendation is that the Hawks should investigate if the relevant senior executives and a non-executive board member of Eskom have not leaked confidential information to the benefit of a third party. And thankfully, Eskom has started with that investigation, and we would obviously ask them to make the product of the investigation available to us, and we will present it to you. And so that gap analysis, Chair, is the one that we identify in the slide analysis, the slide presentation, which you will see at page 37 of the slides. And Chair, we confidently believe that you can rely on that report. Chair, I am going to skip the next report because it's one of the technical reports. It is discussed from page 39 of the slides. With your permission, I'd like to move to the report, which is at page 1492 from file, I think it's 7. It is the so-called G9 report. Yes. 1492. Chair, this is the entity that was engaged in order to assess whether the civil service level agreement that was executed between McKinsey and Eskom was lawful.
You gave some acronym to the report. I'm trying to look for the acronym here.
G9.
It's not to be found here.
It is not to be found here, and I'll tell you why.
Okay.
But
so what's the official name for this report?
we call it G9.
Unofficially.
Because there is. Okay, let me explain to you why we call it G9. Can I ask you to go to page 1510?
1510.
Yes.
Yes.
You will see in the middle of that page, after numbered paragraph 5,
Yeah.
G9 also recommends that Eskom give serious consideration to undertake civil action,
Yes.
possibly against McKinsey, but definitely against Trillion for
Yes.
its conduct at various levels,
Yes.
and are mentioned.
Yes.
And the last paragraph says, G9, it is further recommended that G9 be considered to assist further in terms of supporting criminal investigations and civil recovery of funds. This
Yes.
route will provide continuity, and it is the most practical. It is most practical to embark on, in our respectful submission.
They're asking for the continuation of the brief.
Chair, what we did was to ask the investigators to see whether or not there is something else relating to G9. And they have now discovered a report under the logo and heading of G9, which deals with these matters. And the report reveals how this was the introduction
Oh, okay.
yeah, or the summary of it.
Yes.
But the real report outlining their mandate, who gave the mandate, their methodology of investigation, their preliminary findings, and the steps they suggested going forward is contained in that report.
Okay.
We will make it available to you
Okay.
because we got it more
Late.
recently.
Yes.
And it reveals that their mandate was cut short.
Oh,
Yes,
almost like the Denton's.
almost like Denton.
Johnson's.
Yes.
So, are you going to suggest that I make a note here to say
Yes,
G9,
Chair.
or are you intending to replace this with?
No, we don't want you to replace
Oh,
it.
okay.
But we would add immediately after page 1511 a copy of the real report.
Yes, okay.
So if you could make a note
So I'll
there.
just say G9 report, G9 being in quotes.
Yes.
Yeah, okay, thank you.
And Chair, you'll see that we deal with it from page 41 of the slides. And I believe that nothing more other than what we have said to you is important.
Okay,
And the next report is the so-called CDH report. You will find it from page 1512.
yes.
It's a very useful report because it's detailed in
What
terms
is this one called?
of Cliff Decker-Hoffmeyer report.
Oh, okay.
It relates to the allegations about Mr. Koko relating to the involvement of someone close to him in an entity called Impulse Trading or Impulse
Yes,
International.
It was a stepdaughter or something. Yeah, doesn't matter for now.
Yes, you'll find the name of that person graphically illustrated at page 1526.
Yes,
And the suggestion was that Mr. Koko did not declare an interest which raised questions around conflict of interest regarding that company, Impulse International Pty Limited. And there were investigations, and ultimately findings were made in the CDH report, and Mr. Koko was ultimately charged in the course of disciplinary proceedings. Purely out of interest, Chair, I would ask you to note the following. At page 1593,
yes,
CDH set out the version of Mr. Koko from paragraph 8.1.3 and they analyze whether that version is sustainable on page 1594 from paragraph 8.1.4. and
Yes.
they indicate why even on that version the explanation given was not enough to avoid a conclusion of conflict of interest. And the conclusion is expressed at page 1596, paragraph 8.2.1. There are sufficient anomalies in the explanation actually given by Mr. Koko, and further, many unanswered questions from the explanation given by Mr. Koko, Mrs. Koko, Ms. Choma, and Mr. Patha, for Eskom simply to be satisfied that the matter can be closed. And Chair, as I've indicated, that was one of the charges that was put to him in the second round of disciplinary process, which Eskom initiated in earnest. And Chair, that is one of the issues which the chairperson of Eskom, the current chairperson, talks to in his statement. And he will give you an indication of how far the disciplinary process concerned evolved. But the issue for the Commission is not whether or not there were disciplinary processes. It is whether or not that transaction was impacted by legitimate concerns relating to impropriety. And if so, we would obviously ask you to make a finding in that regard. And so, Chair, that is what we analyze in the slides. And at page 48 of the slides, we indicate outstanding questions or gaps which we believe the Commission should deal with. And it is one of those gap analysis method of investigation where we would say to you, Chair, there is a report, there are disciplinary processes and proceedings, there is a case put by Eskom, and it has not been answered. And unless Mr. Koko comes to answer it, we would submit that we're entitled to make serious findings on it. And Chair, that takes me to the Bauman's report. It starts at page 1598. It's one of those reports which, again, deals with the McKinsey contract with Eskom. I think I've said enough about it, and I'm not going to repeat myself by taking you through the report and the issues it has raised. And quite clearly, one of the recommendations of importance to the Commission is that it recommended the recovery of the amounts concerned through civil processes. And that, as we know, it's a matter which is ongoing. And it also recommended the recovery of money paid to McKinsey's BE partner. And the key findings in relation to the Bauman's report on that score are set out from page 54.
Yes.
Oh, sorry. So I'm misleading you.
Like that's a different one.
That's a different report, sorry. I'm misleading you. Page 50 going to 51. My apologies, Chair.
No, that's fine. page 50.
Yes. The next report is the Butlander report. It was a report undertaken by our colleague Butlander at the request of the chairperson of Trillion Capital Partners. Again, Chair, you remember I told you that there are different Trillion group of companies.
Yes.
The one is Trillion Management Consulting. You have seen its name when we dealt with the Funduzi report. This is Trillion Capital Partners, but it belongs to the same group, more or less the same shareholders. And there is Trillion Property. I'm not too sure where it's going to fit in the course of the hearings.
Are you at 1637?
1637, Chair.
Yeah, okay.
The useful thing about this report is not only the fact that it analyzed the various transactions that McKinsey had with Transnet and Eskom and the role involved, but it also gives you a clear impression of the history of Trillion as an entity and how it was developed and who was involved in it. And the report also gives you some indication of information relating to the dismissal of Minister Nene, apparently had by the then CEO of Trillion or Regiment, depending on where you place him at a given time. And the report discusses in details what information he appears to have had and what he said to his colleagues about that information. And Chair, the gap that we would like to close on that score, although it does not relate to Eskom's inquiry directly, will arise from the evidence that was presented before Parliament and also the statement of the whistleblower that we have already given to you, of a personal account of what the CEO of Trillion or Regiment said to her about what he had known of that confidential information. And this report is useful in that regard because it provides for that analysis. And on that issue, Chair, you can make a note that the analysis begins at page 1693.
Yes.
And Chair, the report also notes lack of cooperation, which Butlander did not receive from parties who were implicated in this investigation. And we do hope that the lack of cooperation displayed before him is something that will not happen in this commission. It is for that reason that we took the initiative to extend a hand of cooperation to parties affected, especially McKinsey, to say, give us your version on specific issue. And we hope that they would cooperate with the Commission in the interest of their future commercial and business relationship in this country. And so, Chair,
of course, whatever information comes out of this report in regard to this issue of information may be relevant to the dismissals and appointments section
Yes.
of the terms of reference.
Indeed, Chair.
Yeah.
Indeed. And that's why we, for our part, have warned some of the most enthusiastic members of our team to rush you to make findings on 1.1 to 1.3 before the completion of the relevant evidence. But if you do feel tempted to make provisional findings on that score, it will have to be clear that they're provisional, because the body of evidence has not yet
Yeah,
been
no, I
completed.
think it's important that evidence that may be important for one section should be taken into account for that section, even if it might appear to belong to a particular compartment. We are not, we're not prisoners of compartments. So something that appears to belong here, if it has got some relevance to another section, then the witness can even be called in regard to the other section, and the evidence
Indeed.
can be used for both.
Yes, Chair.
Yeah.
But we would respectfully suggest that that evidence of information relating to the dismissal of Minister Nene has to be dealt with before you. And people must just come to tell you what information, if any, they had,
Yeah.
and how they acquired that information.
Yeah.
Chair, that is the report of Batlenda. We summarize the key findings on page 54. Yep. And the outstanding questions that we have identified for you are at page 55. And that is our
I see that my liver arch files now have got information on the spine that we talked about. I'm grateful for that.
Yes.
And that would facilitate my job quite in terms of finding the reports and which liver arch files contain what documents.
Yes.
It ought to be also easier to just make a note in your gap analysis where it refers to, it's got a section that refers to a particular report, to just put something that says where that report is in terms of these volumes.
Yes.
So it's going to be easier.
Yes.
Yeah.
Chair, you will see on the score that the present guidance
Yes.
the investigator sought to do
Yeah.
was to give you a number
Yeah.
before the heading of the report. For instance, if you
Yes.
look at page 52,
Let me get there. Yes.
which deals with the report we're looking at, the
Yeah.
Batlenda report,
Yes.
you'll see that there's number 10
Yes.
before the heading Trillion Group of
Yes.
Companies.
Yes.
10 is the file divider number 10,
Yeah.
which tells you where you will find the file.
Yeah.
But of course, we will make it even more clearer.
If you put the volume number of the liver arch file.
Indeed.
Yeah. Yeah. Okay. Yeah. Thank you.
As I said, if you were at page 55, you will see the gap analysis that the investigators have identified. And so what we, for our part, will ask the investigators to do to take forward the conundrum which Mr. Batlenda had is whether they should not invoke the powers of subpoena
Yes.
to call for those records.
Yes. Because he didn't have those powers.
Yes. And we are surprised, Chair, that not even the chairman who instructed him to undertake an investigation of
Yeah.
the CEO of his company would not elicit cooperation by that
Yes.
CEO to produce
Yeah.
that information. It was relevant to the image and commercial reputation of the entity. Now, if the chairperson did not have that power, well, you have the power, and we would certainly appeal to you to invoke those powers to call for the information, either via a subpoena or a summons.
Yeah.
Chair, that takes me to file 11, which I believe is in volume 6.
Yes.
This is a report of National Treasury relating to the appointment of Tegeta and the coal supply agreement it had with Eskom. It is a report which no doubt will be dealt with by those who will be dealing with, I think, the Blackfountain mine. And it talks about the National Treasury's concerns and the involvement of testing at different testing stations, including the SABC, which, as you know, is the domestic accredited institution of sufficient capacity to provide quality stamps on a number of issues. You will see that the report deals not only with the question of the coal quality from the mines owned by Tegeta, it also talks about the grant of the water license to Tegeta and how the water license was procured. That you'll find from page 1747 in paragraph 5.
Yes.
And it talks about the coal supply agreement, and it also talks about the price points and the payments. You'll find them on page 1755, paragraph 9. It also talks about advance payment, Chair. You'll find that on page 1758, paragraph 11.
Yes.
And then ultimately it ends with remedial action directed at the Chief Executive Officer of Eskom and the board as the relevant accounting authority in paragraph 13, in paragraph 1764, sorry, paragraph 13 on page 1764.
Yes.
The analysis of the gap report,
The gap analysis report.
yes, is
Yes.
at page 67. Let's hope Mr. Mokone is-
It's been a long day, Mr. Malaka.
Yes, Chair. And then the outstanding questions are identified at page 68. And as I have said, those responsible for Tegeta in relation to Blackfountain mine will deal with them on the basis of the questions spelled out from page 67 to 68 of the slides.
Yeah.
Chair, I will move quickly because the rest of the reports are research reports. And they fall in the category of the submissions that we believe are useful to the Commission in order to see what had been previously done, especially by academics such as Parry. And their reports are set out from file 12, page 1765, up to page 1836. Aspects of this report was conversed in evidence by, amongst others, Minister Godan, who told you about different components of state capture, including a lot of individuals who are the runners, so he said. Chair, the useful thing about that report is that it gives you a very good timeline insofar as Tegeta and Optimum is concerned. You will find that timeline from page 1822.
Uh, 1822.
Yes, Chair. And you'll see that it gives you the timeline with reference to the specific individuals involved.
Yes.
The timeline goes to the next page. And it's a very useful synopsis of the events which took place during the specific days of the months that have been identified there, Chair.
Yes.
And we'll try to fill up that timeline with reference to live evidence that we will present before you.
Yes. Thank you.
Sure. The next report is, the outer report. It begins at page 1837 by Mr. Ted Blum, submitted to the Portfolio Committee on 18 October 2017. Again, it's a very useful research document, but nothing of significance in terms of the evidence. We have brought it to your attention because it is one of the useful submissions that was presented before Parliament. And I'm not going to ask you to take it further. And then there's something called Eskom's reference book, again by Parry and the Graduate School of Business. The report starts at page 14, at file 14, page 1924. And the slides, Chair, discuss that report from page 77.
I'm sorry, what page?
7 of the slides.
Oh, of these lines.
Yes.
Yes.
And the gaps arising from that report are described in page 79. I can indicate to you that your investigators have not yet gotten to this point of examining the allegations identified in paragraph 1 in relation to the logistics arrangements. I can indicate to you that there is a big legal debate taking place between the Coal Transporters Forum and Eskom and the Department of Energy relating to a different subject, that is of the IPP contracts. Then paragraph 2 of the gaps analysis relates to the diesel contracts. Once again, your investigators have not yet gotten to that point. But what I can tell you about 1 and 2, Chair, is that these are not allegations which arose for the first time because PARI decided to raise them in this handbook. The potential for these allegations was already identified by Denton in 2015 in the report that we have analyzed earlier on. And the board of Eskom was directed to consider that question, especially in relation to procurement. So there is a historical line which becomes important on how the question arose and when did the board of Eskom's attention was drawn to those questions and how it was advised to deal with them. And here we are in the report of PARI. There's an indication that they were not dealt with. And paragraph 4, Chair, deals with the replacement of a damaged generation at Duva in Unit 4.
You are at 3.
3.
Yeah.
Again, your investigators have not gotten to that point, but what I can tell you is that there is litigation going on between a losing bidder and Eskom and the winning bidder in relation to the replacement of this generator. It is before the courts, Chair, and I'm not too sure when the courts are going to finally resolve that issue. I can also indicate to you that the issue about the BEE status of the winning bidder, Dongfeng, it's a matter which is now before the BEE Commission because someone reported to the BEE Commission that the winning bidder did not comply with the BEE requirements of procurement. So a lot is taking place in relation to that issue. But at this stage, the investigators have not yet gotten to it to give us a full account of what is happening. Number 4 is the question of the lucrative maintenance contracts. Again, the investigators are not there, Chair. So to sum up, PARI raised very important issues relating to Eskom, but at this stage, the investigators have not yet gotten to them. Others, of course, as I indicated, are matters of court litigation, and they will run their course in the courts. But once in the fullness of time, the investigators are able to give us the products of the investigation of that issue, Chair, we will certainly come before you on them. And we hope that they'll do so in time before we complete our presentation of Eskom's evidence. Certainly it will not be in this leg of the February and March presentation.
Okay.
Yes. Chair, there is another handbook by Pari. You will find it at page 1950. It's file number 15. The slides deal with that leg of the handbook at page 81.
Yes.
And the findings are identified at page 82. And with the greatest of respect to Pari, we can indicate to you that insofar as they raise question marks around the replacement of generators at Kubech, that issue has run its course before the courts. And I do recall that you gave judgment in one of the constitutional court matters relating to this procurement. It is the Westinghouse case. Yeah.
Now I remember. Yes. Oh, that's the one that was disposed of on locus standi.
From your judgment.
From the court's judgment.
The court's judgment. But remember, your predecessor...
I know that it wasn't unanimous.
The order was unanimous, but the reasons for it were different.
No, the dissent didn't agree that the matter could be disposed of on locus standi. It said we should go into the merits, and it went into the merits. The dissent.
Well, I would be slow to describe it as a dissent. Because it did not dissent from the order you made. It it upheld the appeal, but for different reasons.
Oh, okay, well, yeah, that nuance. Yeah, oh yeah.
But
well, in terms of outcome, it was agreeing with the outcome, but
indeed,
for different reasons. But
yes.
The difference of the reasons lay in locus standi and merits.
In the merits,
Yeah.
yes.
Okay.
So
I remember, yeah.
There is, of course, a body of that judgment deals with the merits of the procurement. And it concluded that there were no questions around impropriety relating to the merits of the procurement. But I must be clear that I should not be understood as suggesting that the issue is closed forever.
Yeah, all I can just say, speaking for myself, is that I certainly did have certain concerns that I would have had to deal with if the matter had gone into if the court had gone into the merits.
Yes.
I certainly had certain concerns
Yes.
from what I had seen in the papers and the minutes of various meetings and the affidavits.
Yes.
And I guess I would say no more than that.
Yes, Chair. And because you say no more, as you have previously said in the court judgment, we would appeal to Pari to respect separation of powers, principle, that there is already a judgment. But they may persuade us otherwise.
Okay, all right.
Chair, that is...
well, I'm not sure what that means before we move away from it. Because there was no pronouncement by the court on the merits. That's for sure. So I'm just saying, since you are saying that, before we move away, I must just say I'm not sure what that means in the light of that. Yes. We might not need to discuss it.
Yes.
Yeah. Okay.
Yes. But again, I mean, if Pari has additional evidence of importance, certainly we as the legal team will commend that the investigators should look into it. Where it takes the commission is something else. Chair, the next report we have dealt with is the NASA report, I'm not going to say anything about it. That is report in file 16. And that takes you to,
That's the same report that you dealt with in the morning?
yes,
Yeah, okay,
yeah.
okay.
And Chair, the last report is the submission of OUTA to this commission regarding all sorts of aspects surrounding Eskom. And we're grateful to OUTA that it has made this submission to the commission and that the commission will definitely deal with the issues that it raises. We have identified the scope of the submission or submissions from page 88 of the slides.
Eight.
Yeah, 88. And we have identified the key findings made in that report on page 89. And we point out that the report is not an investigative report, but an expression of various opinions contained in the submissions, and definitely will take them seriously as and when we present evidence before you and ultimately make submissions. The final report is the SNG report, which you get at page 2088. We identify the report in page 90 of the slides. We take you through the key findings on page 91. And the key finding is in paragraph 3 on that page. And you'll see in paragraph 5, the same finding is articulated on a legal basis. The contract was signed by Dash. He did not have a termination clause, and that was not in keeping with the advice he received from the legal department of Eskom. And the last finding of importance is that the conclusion of that contract, in circumstances investigated by SNG, resulted in irregular expenditure in the sum indicated therein. Chair. Again, for the purposes of the hearing, we're not going to waste much time in regards to that report because it raises an issue that cuts across all of the state-owned entities. And the investigators have indicated that they will provide a comprehensive report on how TNA was involved in different state-owned entities. Chair, I have taken you through this elaborate exercise of presenting these reports to you. We hope that they give you some appreciation of what has been done by other organizations, statutory bodies, constitutional bodies, and private entities, such as the chairperson of Trillion Capital Pty Limited, about the scale and scope of the state capture project insofar as it relates to Eskom. We will therefore proceed on the premise that there have been findings, and those findings in a large measure have not been questioned. We will also proceed on the premise that where we have some concerns about the findings, we will seek to determine whether or not the evidence which will unfold before you supports or repudiates those findings. What remains for me is to indicate to you that after the chairperson of Eskom has testified, there may well be a need for us to present additional information, but in a truncated format around the disciplinary proceedings that Eskom had initiated and concluded, because he will have to explain to us the status of those proceedings. But information which emerged from those proceedings is quite vital, because it takes further several findings which have been previously made. And Chair, other than that,
I guess, depending on a number of factors that we need not go into now, if and when one looks at information coming from a disciplinary inquiry, one would also look at its status via reports such as those coming from Parliament,
yes,
where I believe those who gave witness evidence would have taken the oath or done the affirmation, so on and so on.
yes.
So, but yeah, that's fine. That's fine.
Yes. And Chair, as I said, what that body of evidence would be is to simply address those issues.
Yeah.
And you are aware that there are other parallel investigations by law enforcement agencies.
Yes, yes.
We would want to make sure that we don't disturb or prejudice what they're doing.
Yeah, yeah.
And to the extent that they approach us and seek our assistance on how we should guard against presenting some other form of evidence, obviously we'll seek your guidance.
Yes, no, that's fine. I guess we'll just have to take each approach or request on its own merits as it comes and weigh the pros and cons of taking a particular approach or not in the light of everything else. But you are correct in saying that wherever possible, we would seek cooperation. We would seek to cooperate with them just as we believe they should seek to cooperate with us. Yes. Yeah, okay.
So the next step of the document presentation, Chair, is going to be quick because it relates to the body of evidence that was before Parliament. And as I indicated, it is in two categories. The first is the statements given to the portfolio committee by persons who were called upon or decided to testify of their own volition to the portfolio committee. And then there is a second body of information, which is the transcript of the actual evidence they gave and the record of questions and answers put to them by members of the portfolio committee. Chair, the person who is best placed to take you through that information is my colleague, Ms. Norman. She has done a lot of work in order to take you through them. And she has agreed to do so, and I am grateful to her. She will definitely do it tomorrow to avoid information
Yes.
overload on our part, because as you know, once there is a hanger of information overload, the first victim is focus. So we would like to avoid that for today.
Well, we have run out of time for today. That's the
Yes.
most important one,
Yes.
because otherwise you know that when necessary we go beyond 4 o'clock.
4 o'clock.
Yes.
Yes. So we will simply ask you to rob the commission of 10 minutes of its normal time and adjourn earlier.
Yeah, no, that's fine. We will adjourn the proceedings until tomorrow. We'll resume tomorrow at 10, in the morning. The commission adjourns.
Thank you.